Good afternoon, everyone. Welcome to the webinar this afternoon. Today, we'll be presenting about domestic violence, some practical tips, and also talking a bit about the recent legislation updates. My name is Stephanie Brown, and I've been a solicitor at Michael Lynch for around 2 years now, and I do practice quite a bit in the domestic violence space, so hopefully I can give you guys some knowledge about that area today. This is just a bit of an overview of what we'll be going through today. So I'll take you through a bit of the backdrop of domestic violence in Queensland, talking about the definition of domestic violence, and then going through the application process and the court process and what happens if the court does make a protection order. And then I'll also be talking about some of the recent legislation updates and what effect that's had in the domestic violence space in Queensland. So in recent years, domestic violence has gained a lot of attention in the media and in politics, and that's due to a number of things. Obviously, Rosie Batty's been a huge advocate for domestic violence awareness in Queensland, and that's had a big effect on the coverage it's received. And there's also been quite a few high-profile domestic violence incidents that have been covered in the news, and some of those have resulted in homicides, which have had huge attention in Queensland. So as a result of this increased awareness and attention for domestic violence, in 2015 the Premier ordered that there be an extensive review of domestic violence in Queensland, and the result of that was the Not Now, Not Ever report, which was headed by Quinton Bryce. And this report has then since that time been the catalyst for major changes to legislation in Queensland between 2015 and May 2017 when the most recent changes came in. And a big result of this report has been an increase in awareness of different forms of domestic violence. Obviously, most people are aware that physical violence can be domestic violence, but it's also increased awareness around other emotional and psychological forms of domestic violence as well. And that also has the awareness around that area has also resulted in an increase in the number of applications being made in Queensland as well. So between 2006 and 2012, there was an average of 24 deaths per year in Queensland that were linked to domestic violence, and that actually amounts to around 44% of all homicides in Queensland for that period. And between 2015 and 2016, there was an 18% increase in the number of applications made in Queensland, and 73% of those applications were brought by the police. And as part of that increase in awareness and the risk around domestic violence in Queensland, we have seen, I guess, an increase in education for police, particularly around those other forms of domestic violence and the risks associated with that psychological and controlling behaviour, more so than the physical violence, which obviously the police are attuned to and are aware of. And although domestic violence, obviously victims and perpetrators can be either male or female, it still remains the case that overwhelmingly domestic violence is a gendered issue. Approximately 74% of aggrieved persons were female and 75% of respondents were male in the 2015 year. So although there is awareness around the fact that males can be the victim of domestic violence, it still does remain a gendered issue today. So this just takes you through a little bit the legislative definition of domestic violence, which has been broadened in recent years, and the relevant legislation is the Domestic and Family Violence Protection Act 2012, and that has been updated with the recent changes. So Section 8 of that Act provides a broad definition of domestic violence, which is behaviour towards a person that is physically, sexually, economically, emotionally or psychologically abusive, coercive, threatening or controlling. So as you can see from that definition, it is an incredibly broad definition, but helpfully the Act does also go on to give, I guess, a non-exhaustive list of examples. So sections through 8 to 12 of that Act go through some of the, I guess, the behaviours that can fall into that definition of domestic violence. So some of those things are damaging or threatening to damage property, coercing a person to behave in, to engage in sexual activity, causing or threatening an animal, and that's something that does come up often. Unfortunately, a lot of the refuges that people often need to escape to get out of these relationships aren't able to take animals, and that's often a reason that people don't actually leave these abusive relationships, is the threat of harm to those animals. So that's why that has been included in the definition of domestic violence. Unauthorized surveillance of a person, and that can also be a huge issue these days with technology, and there are certain apps that can be put on people's phone, and sometimes they might not know, or if phones are even in a partner's name, they may be able to get phone records for that phone, and they can then trace where someone is. So it's important, I guess, to keep that in mind if you are dealing with people who are the victim of domestic violence, and making sure that they're attuned to the fact that that may be a risk as well. Exposing child to domestic violence, following a person, repeatedly texting or emailing a person, preventing a person from keeping in touch with family or friends, coercing a person to sign for finance or loans, preventing a person from obtaining employment, and obviously that then prevents them from having their own financial independence as well if they're unable to obtain employment, and coercing a person to obtain social security benefits. So there are a lot more in those sections of the Act. If you did want to go through and have a look at them, there are, I guess, some good examples, and it does give you some light into what that broad definition of domestic violence can mean. So when filing a protection order, there's a form that needs to be completed that then gets filed with the magistrate's court. Domestic violence is covered under state legislation and therefore is enforced by the state courts. This is what the form looks like. This form's available on the court website, and I've just given you the link there. And there are also police stations often have copies of this, and local magistrates courts often have copies of this form as well. As you can see on that page that I've given you there, the aggrieved does need to fill out their details. Obviously, that sometimes can be a safety concern. If someone has fled from an abusive relationship and they don't want the other person to have their address or contact details, then they don't need to fill that out, and they can fill out a separate form that goes to the court. So just something to keep in mind, just because it's on the form there, you do need to think about safety as well. And there are two ways that an application for a protection order can be made. They can be brought either by the police, or they can be brought by the aggrieved person that is involved in the domestic violence. So I guess usually what happens when there's a police application, and as I mentioned before, there is a high percentage of applications that are brought by the police. So often if the police are called out to an incident at a property following a domestic violence incident, whether that's called by neighbours or people actually involved, then the police can consider the evidence and consider the facts and determine whether they will then file an application if they consider it's necessary to do so. And generally what will happen is the police will interview people on the day or the night when they've been out to the property, take any witness statements, take any evidence they need, and they will then complete that application form that was on the previous slide, and they will file that with the magistrate's court, and that will start the process. With some of the other, I guess, less physical and less violent forms of domestic violence, so that financial control or the psychological abuse, sometimes it's not necessarily the case that the police have been involved, and in that case it may be that the aggrieved needs to file their own private application, and same kind of forms, they just need to fill out that process and fill out that form and file it with the magistrate's court. And in that case, they'll then be both the applicant and the aggrieved. In the police applications, the police prosecutor will be the applicant, and the aggrieved is obviously the person that's been the victim of domestic violence. Just in terms of the terminology, obviously the aggrieved is the terminology that's used in the form and in any orders that are made by the court, and the perpetrator of the domestic violence is actually referred to as the respondent. So that's the terminology I'll be using today. So if you're wondering what the difference is there, that should hopefully clarify that for you. So in that application form, when it's filed, there is a section that asks whether the aggrieved or the applicant considers it necessary that the court makes a temporary order. And basically, excuse me, basically, unfortunately, there is often delays in the court process, so there will be a delay between filing the application and having any final hearing for the judge to make a final decision about whether there should be a final order. So the temporary order is in place to really protect the aggrieved person in that interim period. So I guess at that first court date, when the judge will make a decision about whether a temporary order should be granted, it's it's often the case that the magistrate will only have access to the information that's contained in that application form that I showed you on that previous slide. So it's really important to make sure that there is as much information and as much detail on that form as possible, because that then means that the magistrate's going to be able to make a decision about whether the temporary order should be there. So the details that need to be included are dates, times, locations, who else was there when any of these incidents have happened, what happened, and how the aggrieved felt at that time. So as much detail as you can include about those things, because that's the only evidence that the magistrate will have at that first court date. The application form also has various conditions that can be included in the order, and the court has the power to include any conditions that they think are necessary depending on those circumstances. So the standard condition must be included in all orders, and it's included in temporary and final orders, and that condition basically just reads that the respondent be of good behaviour and not commit domestic violence against the aggrieved. So that condition will be on any order that you see. And the magistrate also must consider whether there should be children under 18 named on the order, and that they then will be included, and the condition will read that the respondent be of good behaviour to the named persons, who will be the children. And it may also be necessary to consider including any associated persons as well. So if there are other adults living at the property, or the other one that we sometimes see is if the aggrieved has repartnered and there's been threats made to the new partner, the new boyfriend, or the new girlfriend, that can be obviously that they should be included on the order as well for their protection. And the other conditions that can be included on an order, there's a variety of things, and these can be tailored to the specific, I guess, circumstances of the domestic violence. So things like not approaching a person, not remaining at the property, not approaching the school if there are children involved, not contacting the aggrieved. But I guess it's important to consider what conditions will actually protect that person. So if one of the allegations is that the respondent has sent harassing text messages 100 times a day to the aggrieved, then there really should be a condition in that order that says that the respondent not be able to contact the aggrieved by any method. The other condition which the court, under the recent changes, the court must consider whether for the aggrieved protection they need to make an order that the respondent actually be excluded from the home. And that can obviously have huge ramifications, and often that's something that comes around that we see when we see clients for family law matters, is that one of them's been excluded from the home due to an ouster order, and that order can be made on a temporary basis or a final basis. So it can have huge ramifications if one party then needs to go and find alternate accommodation. That can be quite difficult, but it is obviously there to protect aggrieved people, and I guess it's important. Often people don't have the finances or the resources, particularly when they have been the victim of domestic violence, to then set themselves up in an alternate accommodation. So this then allows the court to consider whether the respondent should actually be excluded from staying at the home. And the other, I guess, condition it's important to consider, there is other ramifications for weapons licenses, and sometimes this is something that we see a little bit here, where there are people who are responding to a domestic violence application who actually need to use weapons or have weapons licenses for their employment, and it's often not I guess, something that the aggrieved or the police have thought about and how that's going to affect their employment. So when the temporary order, if there's a temporary order made, that will suspend any weapons license that someone has, and a final order will obviously terminate that weapons license. And the termination of the weapons license, if a final order is made, is actually for a period for 5 years after the end of that order, so potentially for a 10-year period that someone could be excluded from holding a weapons license. The other conditions to consider obviously are to think about how any protection order may affect parenting arrangements. Often we see these domestic violence proceedings being run simultaneously with family law proceedings, and often the event around separation has resulted in an application for protection order. When there are children involved, any protection order can also affect how a party or a parent is going to be able to spend time with the children. So if there are protection orders being made, then you may need to also request that there be what we call a family law exemption put in that order. So basically, that the conditions, as I spoke about on the last slide, will still be in place, but there will be an exemption that usually reads something along the lines of, the respondent not be able to contact the aggrieved except for the purpose of having contact with the children or arranging to have time with the children, or to attend a mediation, conciliation, or court event. So obviously you don't want a protection order stopping someone from seeing the children if there is no risk to the children, and also you don't want it stopping parties from being able to speak about and resolve their other family law matters which may be ongoing. So just considering whether that exemption needs to be in place is important as well. Okay, so I'm just going to take you through and speak a little bit about what the actual court process is. Unfortunately, as with a lot of these things, the court process can be quite long and it can be very emotionally draining on people as well. So hopefully with having some information about what that process looks like might make that process a little bit less I guess, emotional for people. So an application is filed, and as I mentioned, that can be filed by either the police or the aggrieved person themselves. And the police then serve a copy of that application on the respondent. So he will have a copy of all the information contained in that application form, and will also be aware of what the allegations that the aggrieved has made. The next step is that application, when it's filed in the court will make a note of what date it's going to be listed, and it will be listed for a mention, which is essentially just a kind of check-in date with the magistrate to determine what's going to happen from here. So at that first court date, the magistrate will decide whether a temporary order should be granted, which we spoke about before, and what conditions should be included in any temporary order if they do grant it. Usually at the first court date, either one or both parties will indicate to the magistrate that they haven't necessarily had time to obtain legal advice, and that's because often that court date is very shortly after the aggrieved has filed the application. So it may only be a few days, they may only be served with it in the few days before. So generally the magistrate and the court will allow parties to obtain that legal advice, and that date may just be adjourned for a short period to allow that to happen. And at any time when the court is adjourning a matter, they will relist it for another date, so the parties will be aware at what date they need to come back. And usually there are 3 or 4 court dates before a matter will actually get a final hearing in the magistrate's court. So at that first court date, or at any, I guess, time along that court process, the respondent has a number of options for how they're going to respond to this application. So the first option is that, and this I guess will depend on whether it's a police or a private application, but sometimes what happens is that the aggrieved actually decides that they don't want to continue with the application for the protection order, and they will then withdraw that application and no order will be made. This is sometimes something that we see if, and particularly when it's running in conjunction with family law stuff, if there's no grounds for an order, and like I said, if it is a private application, it may be that parties have around separation, it's obviously a time of high conflict, and sometimes that can lead people to filing applications which may actually not have any grounds and which wouldn't be granted by the court. And in that case, sometimes once solicitors get involved or once there's been some progression in the family law matters, then people agree to withdraw those applications. Very different story if that's a police application. Sometimes we see cases where there's police applications made and the aggrieved then goes back later and decides to tell the police that they actually want to withdraw the application and they don't want an order to be made against their partner. And the difficulty with that is that the police are very reluctant to withdraw their applications when they have been made by the police, because there is a risk that aggrieved people have been pressured into telling the police that they want to withdraw the application, or have been pressured into changing their evidence about the incident by the party that is actually committing domestic violence, and that's a huge risk. And the police, and we've seen the police have been very reluctant and haven't actually withdrawn applications, even if the aggrieved and the respondent are both on the same side saying they don't want the application to proceed. The second option there, in terms of either responding to or settling an application, is that the aggrieved could agree that the respondent sign an undertaking. So an undertaking is a little bit different to a court order in that it's still a promise to the court and it still gets handed up to the magistrate at the magistrate's court, but it's not actually an order of the court. So it's more a promise to the court, and you know, arguably if you're in breach of that, then you potentially in contempt of court. But the idea is that the respondent sign an undertaking, and that can be on similar conditions to what we spoke about before. So all those things: not to commit domestic violence, not to contact them except to talk to the children. And they sign that and it gets handed up to the judge. What would happen usually if someone does agree to sign an undertaking, the aggrieved will then withdraw their application, but the court will have a note of that undertaking. So if those two parties end up back in court 6 months later and the aggrieved has again alleged that there's been domestic violence, then the court would pull out that previous undertaking and say, well, previously you've signed this undertaking and now you've breached that. So the court would have regard to that when they were making an order. The third option there is that the respondent could agree that the order be in place on a without admissions basis. So essentially that's the respondent saying, for the purpose of, you know, maintaining a co-parenting relationship sometimes, or for the purpose of not having to go to the cost of going to a full hearing, I'll agree that there be an order, but I'm not necessarily agreeing that the allegations in the agrees application are true. So that's often something that we see happen, and that can be a bit of a negotiation about what terms should be included in that consent order, and the magistrate will make that order in court. And the final option for people in terms of responding to an application is obviously that they can contest the application. Obviously, in Australia, people have a right to defend and, you know, be heard and due process in court, so they can actually challenge the evidence of the police or the aggrieved and go through the process of having a hearing and having their evidence heard in court. And ultimately, the magistrate will make a decision about whether the order should be made on a final basis after looking at all that evidence. So if the matter hasn't settled and the respondent indicates that they are going to contest the application, then obviously the court will be in charge of guiding that process. The court will then, at that court date, provide directions to both parties, and essentially those directions give some dates as to when the matter will be heard and as to when any written evidence, affidavits and witness statements need to be filed. And it's really important that parties comply with those orders, because if they have to file an affidavit by a certain date and they miss that date, then the magistrate can potentially not have regard to that when they're making a decision. And then the matter will be listed for a hearing. Both parties will give evidence in addition to their written evidence, and both parties can be cross-examined about the evidence that they've given. And one of the other changes that came in the recent updates is that aggrieved persons in a domestic violence application are classified as special witnesses, and that then means that there are some restrictions around the aggrieved person being cross-examined by the respondent in court. There are a number of reasons for this, and really it's just to highlight that court is obviously can be a, I guess, scary and foreign environment, and on top of that, a respondent questioning and cross-examining someone who they say has committed domestic violence against them is obviously can be another form of domestic violence and can put huge pressure on that aggrieved person to either change their story or to change the evidence that they're giving. And so special witnesses, once they're in court, there are a number of things the court can do. So they can limit the amount of time that they're going to be cross-examined. There's also, I guess, special measures so they can put a screen up between the respondent and the aggrieved so they don't have to look at them directly. The aggrieved can have a support person with them to help them through the questioning. They can also record the evidence beforehand so that it's just being a video being played, or they can have the aggrieved give evidence from a separate room, so by video link into the courtroom. So again, they're not face-to-face with the respondent. And after evidence, and the domestic violence proceedings are usually, the hearing's always done in one day, and the magistrate will then give a decision, usually that afternoon, about whether the protection order should be made on a final basis. And so in terms of when the court will grant a final protection order, there's 3 elements that the magistrate must be satisfied of. So the first element is that there's a relevant relationship between the parties. And a relevant relationship is either a spouse, a family relationship, or a couple. And in most of the cases that we see, that's fairly easily made out. Ex-partners is the most common one that we see. But obviously, if there's, for example, work colleagues who have made allegations, then that doesn't actually fall under the domestic violence legislation, and that's a matter for the police. The second element is that there has been an incident of domestic violence. And as I mentioned, the definition of domestic violence is incredibly broad, so it's fairly easy to make out that there has been at least one incident of domestic violence. And the third element is usually where there's the most contention in the courtroom if the matter has been contested, and that element is that it is necessary or desirable to protect the aggrieved for the final order to be made. So that means that the court needs to be satisfied of a few things. You know, for example, that the violence is ongoing, that there's been a pattern of this violence, and that there's, I guess, a pattern of behaviour there that shows it will continue, that there's a need for ongoing communication between the parties. So if the parties have children together, then it's likely that they're going to need to keep communicating, and in that case the court's probably more likely to think it is necessary for there to be a final order. If, for example, you've got a couple who separated 6 months ago, have no children, haven't done have done their property settlement and haven't spoken to each other in 6 months, then the court may look at it and say, even though there was an incident at separation, that incident does fall in the definition of domestic violence, there's not actually a necessity to protect anyone for an order to be made. So the court will look at what's actually necessary in the circumstances. And if an order is made, obviously then the purpose of that order is to protect the aggrieved, and any breaches of that order are taken very seriously. So the making of the final protection order is actually a civil matter. It's not a criminal matter, and it doesn't show up on anyone's criminal record. However, the breach of an order, if that's found to be true by the court, is a criminal matter and is taken very seriously, and it does come up then on someone's criminal record. So breaches of orders are, I guess, very serious matters and really need to get criminal law advice if that's something that comes up with anyone that you're speaking to. So if there's an order in place, it's not the case that automatically that a breach will be reported and a criminal record will be, I guess, noted against that person. So the aggrieved needs to report any breach to the police, and the police then have the power to investigate that. So they would usually contact both parties and find out if there's been an incident and what the circumstances around that incident are. The thing that we often see is parties will have a temporary protection order or a final order that says they can't contact the aggrieved, and then the aggrieved will start sending them text messages which they respond to, and then they get worried that that's going to be a breach. So the police will actually look at that and say, you know, this person's got text messages from you and you are asking them questions, and how can that be a breach then if you've initiated contact? So there is a little bit of common sense when we're looking at what is actually a breach of the order. It's not, I guess, a black and white process. But in saying that, obviously people should always try and comply with the order at all times. Once the police have investigated, if they think that there has been a breach, then they can charge that person, and again it will go to the magistrate's court to determine whether that's been a breach. And even in circumstances where a temporary order is made before a final hearing and something, if the order's withdrawn, the application's withdrawn, or the magistrate decides not to make a final order, you can still be in breach of those temporary orders, and that again the police take it pretty seriously. So I have seen cases where the final order application has been dismissed by the magistrate and the police have still pushed on with charging someone for a breach of a temporary order. So it can be, I guess, it is taken seriously by the police who have to see this stuff on a day-to-day basis. So just some practical tips, I guess, if you do have clients or people that you're speaking with who are raising these issues. Obviously, if they can get legal advice before they file an application, as I said before, going through all those conditions and making sure there's information in there to get a temporary order if it's needed, it's really important to have all those details set out in the application. So if they can get legal advice before filing that, then that can sometimes assist the process to go through a bit smoother. If they can't get legal advice before that date, then most of the magistrates' courts do have duty solicitors at court on the DV day when they have the DV lists on. So the client, or sorry, the person that you're speaking with usually can get in to see that duty solicitor on the day, and that they'll be at least able to talk them through the court process, and hopefully, and in some occasions, the duty solicitor will actually go into court before the magistrate and appear for the person. Obviously, courtrooms are quite foreign to a lot of people and can be quite intimidating. So even just having that touch base is to explain the process on the day can assist people as well. If it's a police application, then the police prosecutor will be at court running through the court process, and they will usually stay in contact with the aggrieved, and they will contact the aggrieved to get any further evidence they need. And even though it's a police application, I would still recommend that the aggrieved person actually attends court on the listed court date. And that can sometimes be something that the police will leave to the aggrieved, or sometimes they may say it's not necessary. But I think it's important. The police, when they are running matters at court, they often have a huge number of matters that they're running, and sometimes it can be easier if they are having discussions with the respondent about possibly consenting to an order or possibly withdrawing an application, then they can get instructions from the aggrieved and keep them updated about that process on the day, and that can be a little bit easier if they're there. And on that note, obviously, when matters are listed for protection order hearings or mentioned days, there are usually sometimes 20 or 30 matters listed all on the same day, and they'll all be listed at the same time, so parties can be waiting around for a long time. And most of the magistrates' courts have a separate safe room where aggrieved parties can go, so they're not sitting across the waiting room, sitting across from the respondent. So I guess just making people aware of that so they know that they can ask for that when they're at court. And just, I guess, some practical tips for when people do go to court. Obviously, people need to be there on time and at the time that they're listed for. And there's usually it's some old ladies or some old men who are called friends of the court. So they're volunteers that assist the court with just the day-to-day running of things. And they will usually have a bit of a checklist, and people can just check in with them and they'll get their names ticked off, and they'll tell them when they are ready to go in. And as I mentioned before, if a respondent does go to a court date and they may not have had an opportunity to get legal advice, they can always ask to adjourn that day so they can get that legal advice. And whether that's legal advice with the duty solicitor at court, whether that's private legal advice or advice from a community legal centre, I guess they should always ask for the adjournment because it is a serious matter. Okay, so that's just finishing off the first section, which is going through some of those, the court process, and giving a bit of background to that. So now I'll just go through the recent updates to the legislation that have come in, and some of these have come in only very recently at the end of May this year. So we're still yet to see in some cases how that's going to filter down through the courts and how the magistrates and the police are going to handle these updates. So some of them, it's more this is what the legislation says, but there may not be necessarily any indication as to how that's going to filter through. So the first update, and this has been a major one, is the length of any order that is made. Previously, the orders were in place until specified or for a period of 2 years. And the update that's just come in May is now that the orders will be in place for a minimum of 5 years. And it's, instead of just being a date specified, if the order is to be for less than 5 years, there have to be sufficient reasons for the order to be for less time. So that's something that we are having some difficulties with. Obviously, a 5-year order, as I said, with the weapons provisions particularly, can have ramifications for a long time. So there are still, when you're consenting to an order, it may be that you want to consent for a shorter period of time, but you still need to be able to give reasons to the magistrate as to why that shorter period is acceptable in the circumstances. And I've recently had a matter where it was a police application, and I was acting for the respondent, and we did manage to reach an agreement for him to consent to a shorter period, but we still needed to then attend court and explain to the magistrate why that shorter period was appropriate, even when the police had already agreed to that. So it is, I guess, the magistrates are taking control of that process a little bit more, it seems, and being a bit more invested in what conditions and what conditions the consent orders are being made on, and making sure that they still allow for the parties to be protected. The next big update, and this obviously has ramifications in the family law space as well, is previously magistrates did have a discretion to consider any family law orders, and they could modify or suspend those orders if it was necessary. And sometimes that was necessary, obviously, if there's a conflict in the operation of a family law order and a protection order. And the feedback in the Not Now, Not Ever report from people was that this power wasn't actually being used because it wasn't strong enough, and magistrates were very reluctant to actually use that discretion to amend family law orders. And that's probably for a number of reasons. Family law orders obviously are a federal court, and the magistrates court doesn't practice family law matters, so I guess it's difficult for them to say, without all the evidence that the family law had, whether those orders should change. So this discretion just wasn't being used by the magistrates at all. So the recent update really broadens this power, I guess, and solidifies this power for magistrates, and they must always now consider any existing family law orders and consider whether those orders should be amended, varied, or suspended to resolve any inconsistencies. So the magistrate must have regard to those family law orders when they exist, and they need to then consider whether that should change. And as I mentioned before, we're still yet to see how this is going to affect what the magistrates are doing in the courts, and whether they will then be, I guess, more willing to amend those family law orders. And it'll be interesting to see if that does then have an effect in terms of people then having difficulties with their family law orders. I guess usually around separation, if there are domestic violence and family law proceedings ongoing at the same time, the length of time that matters will be in the family court will be for a lot longer. So usually the domestic violence stuff is resolved first, so it may not come up often, but obviously if you've got historical family court orders and there's ongoing domestic violence issues, it may become an issue. The next change that is certainly been a positive one, I think, is that previously aggrieved people from interstate actually needed to manually register any interstate protection orders when they got to Queensland, which obviously just meant that they had to go through another process and they didn't automatically have that protection once they got here. So the new amendments actually allow for automatic recognition of interstate orders in Queensland, and this was particularly an issue where we've got places like Tweed Heads where you're very close to the border and people may have moved just over the border to get away from violent relationships. So this also means then that those parties are protected in Queensland, and any contravention of those interstate orders is also going to be treated as if it was a breach of a Queensland order, so they will be taken as seriously as if it was a Queensland order. One of the other changes that came in relates to cross applications. So it's quite common when one party has filed an application for a protection order that the other party will respond by filing one against that person. So they're called cross applications. This is particularly common when we've got family law proceedings and parties may be filing in conjunction with having the ongoing family law background. So the amendments now require that these applications be heard together, and that's really important because it was highlighted that there were circumstances where a party had filed an application for a protection order in a magistrate's court and the magistrate wasn't aware that there was also an application against that person, and obviously it makes it very difficult to then determine whether the application is necessary in those cases. So the magistrate will hear them together now, and they then make a determination about which of those two parties is actually most at risk and most in need of protection. And this is really important because there were cases, unfortunately, sometimes we do see cases where an application for protection order is not really filed for the right reasons and there's no grounds for a protection order, and people are really using it as a tool of manipulation and really as another form of domestic violence against people. So it's important that the magistrate knows about all the applications that are on foot, and the magistrate can then look at all of those applications and decide who actually is in need of the protection and make a final protection order in that person's favour. The next change that came in expands the police powers when they're responding to domestic violence incidents, and in particular expands their powers around issuing police protection notice when they have been called. So police can issue a police protection notice immediately where it's reasonably necessary to protect the aggrieved, and one of the changes particularly is that they can now do that whether or not the respondent is actually at the property when they arrive. And these police protection notices can include a cool down 24-hour period, which excludes the respondent from the home and also means that they can't contact the aggrieved during that period. And that police protection notice then actually acts as an application for protection order filed by the police. So that police protection notice also has the added benefit of then going to the magistrate and starting that application for protection order process. And the other change as well around police powers is that previously police couldn't refer parties to service providers or assistants unless they consented to do so. And obviously that caused some problems when people have been in domestically violent relationships. They may be reluctant to accept the assistance of police and may be reluctant to engage with police. So the police are now able to refer parties to those service providers without consent where there has been a threat to a person's life, safety, or if the person has committed domestic violence. So just an expansion of those powers to ensure that people are protected in those circumstances. And one of the other big changes actually was made to the criminal code. So it isn't in the Domestic Violence Act, but this is a separate provision for non-fatal strangulation, which is now a separate standalone offence under the Criminal Code. And the reason this was highlighted is there was a lot of research done into choking and non-fatal strangulation as an offence, and it was really a huge predictor of an escalation of that domestic violence in the relationship. So this has really stemmed from, I guess, a lot of that media around those high-profile cases which resulted in homicide, and the research showing that choking was a predictor of that escalation in that violence. So the maximum penalty for that offence is 7 years. So it is being taken quite seriously. And just some of the other things I wanted to mention, and this isn't on the slides, is there was also an amendment for the information sharing provisions. So child safety, police, emergency services being able to better share information about aggrieved parties, and in circumstances where that's needed for the protection of life and safety particularly, they don't necessarily need to have consent. And the other big change that's happened in Queensland as a result of that Not Now, Not Ever report is that we do now have a specialist domestic violence court, which is located at Southport down at the Gold Coast, which was highlighted as one of the areas that had the greatest number of applications per capita for domestic violence. And that was, I guess, to make sure that the magistrates do have the skills required to deal with this very specific area of law and the associated psychological and family law issues that come along with that. So that court's been set up, and I believe they're rolling out some trials in some other magistrates' courts around Queensland. So just some of the things, I guess, that we hear when people do seem to be they're struggling to accept often that they are in a domestically violent relationship, and that particularly seems to be a problem where it's not necessarily that physical violence, but it's those other forms of violence that I spoke about earlier. So things that we hear are things like, no one will believe me, how can I prove anything, it's all happened behind closed doors, he's never hit me, so that's not domestic violence. She's always had control of the bank accounts. That's the way our relationship has been. And she's threatened to hurt herself if I don't stay. So that last one particularly, and that's one of those examples that is highlighted in the Act, is that parties threatening to commit suicide can be an act of controlling behaviour. And again, some of these things all come down to context, obviously, as well. So context around the relationship, how that's making the aggrieved person feel, and also a pattern of controlling behaviour if that's what's happened in the relationship. So again, just looking to those sections of the Act if you're hearing some of those things. And what do you do, I guess, if you have a client or a patient that's indicating that they are in a violent relationship? So obviously the first thing to be aware of is the safety of that person. If it's urgent or if there's an immediate threat to someone's life, then obviously the police are the first people to call in that case. Many of the stations now in Queensland also have specific domestic violence officers who will assist people to complete applications, or will file the police application on behalf of that person if it is necessary. If it's not an urgent matter and there's no urgent threat, then if the client could obtain legal advice prior to filling out that application, and I went through that a little bit before, obviously they can file it without legal advice if they need to, and the form's online and they could just take it into the magistrate's court, or as I say just above, go to the police station and see if they can assist them to fill it out. And there are also a number of not-for-profit services in Queensland that clients can be referred to, and I've got some details on an upcoming slide. And if you have someone comes in that says they're actually responding to an DV application, then they really must obtain legal advice. As you can see from going through the chat today, it can have serious ramifications for people, so they really should obtain legal advice. And the application needs to be taken seriously, and often urgent attention is required because those court dates are quite shortly after the application is filed. If they can't get legal advice, and as I said, seeing the duty solicitor up at court, and thinking through those options as well to settle or reach agreement to get, if they don't want to contest the application all the way through the courts, and just making sure that they know that they really must attend those first court dates, because the court can make orders in someone's absence if they don't appear on the day, if they know that they've been served. So these are just some of the service providers that you may like to refer people to. DV Connect have both a women's and a men's line, and the phone numbers are there. The Elder Abuse Helpline, which has become, I guess, more well known in Queensland at the moment, that there's elder abuse, so there's a hotline specifically for that. Women's Legal Service also provide assistance to women who have been the victims of domestic violence, and they give advice both about domestic violence matters and other family law issues as well. And then there's also a link there to the list of community legal centres in Queensland who do similar kind of work. And also at the bottom of that slide, I've just given an update to the most recent version of the legislation, which was updated. And if you've got any questions following today, you're more than welcome to email. The email address is there, and you can just attention it to me, so Stephanie. And there will be a feedback survey that pops up at the end of today as well. So if you'd prefer, you can just put in any comments or questions that you have, and we can get back to you. And you are able to download the PDF as well, so there should be a link there on your page to download the PowerPoint slides, so that you'll have those. And these are just our contact details, so if you do have clients or people that need to come in and see us, we do a fixed fee consultation as well, and they can just give us a call and we can speak them through that process, and hopefully we may be able to assist. So that's all from me, and hopefully that's been helpful. Thanks and good afternoon.